Oh, you're sneaky. Sneaky bit.
In the car.
You know, son. My work. See it?
Did you go live on me too?
Yeah, I already did
Close
that.
it out.
I closed that out. Somebody's got their, can you all hear me?
Yes, we can.
Yes.
Yes.
Thank you.
Hold on, we're getting some type of feedback. Wait a minute. Where? Hold on a second. The computer systems went down in our building, so that's why we're late coming on. I don't know why. Yeah, I went live and then I closed it out.
Right button. So. See it.
Can you all hear me?
Yes.
Yes.
Judge.
Yes.
Something's going on. I did live. You wanna go off live and then go back on the line? All right, we're testing the sound, so no, we still get feedback. Go off the line. And see if we can go off the line and come back on the line. Yeah, because remember you just told me to close it instead of taking it on. Maybe that's it. Now close it out. Can you all hear me?
Yes.
Yes, Judge.
Yes.
That's what's
Need to close that.
Yes, Your Honor.
Okay. All righty. Now we're rocking and rolling. We are going to go down our list. If you are here, let the clerk know you are here.
Yes, I'm here on,
No. We're
Oh.
gonna call out the list and you let us know if we're here, okay?
okay, I'm sorry, Yana.
Are the parties on Allen here? Armstrong?
Come on, table.
Castor Mosius?
My guy.
Crosby? Davis?
Yo. I don't know if that's me. I don't know if that's me or somebody else.
Yes, that's you, but I want the attorneys to check in, please.
Mute your phone, Mr. David Seegers, for me, okay?
Okay, thank you.
Well, the attorney's coming here, but I know he has wire here. I don't see wire here.
For Realio?
Mike,
Corey?
for the
For
people.
Realio?
Attorney McWilliams on Dayron Williams.
No, we're calling out the names. Please listen for the name of the defendant.
Corey? Gray?
Here on Gray, Taylor on Gray.
Okay.
Hawkins?
Here. Hawkins is here.
Hornstein?
AP Dornick on Hornstein. I don't see a defense attorney. It's Mr. Kearney.
Hosler? Howard? Johnson? Lee?
Hostler is here, but my attorney's not. I don't know.
Purnell? Saylor? Thomas?
Good morning, Your Honor. This is APA Grace Proton Thomas.
Thank you. Wade? Walker?
Would that be Susan Walker, Attorney McWilliams?
Yeah.
Yes. Susan Walker, yes.
She's on the line also.
Thank you. And Watkins?
Yes, I am on the line.
I don't have a Watkins. I must have a different document. I only have a Walker, Williams, and Woodmore.
I'll give you another document. Williams? Woodmore?
Would that be Dayron Williams?
Anthony Williams. I don't have a Dayron Williams.
Oh, I do have
Okay.
Dayron.
That would be an AOI, and he's in custody.
Oh, he's in custody.
Kins, I don't have any representation.
These are only out of custody matters, not in custody.
Thank you. We'll talk later.
Okay, thank you.
Okay, that's it. That's the
All
document.
right, let me have a new one. I had something else.
I'm here on Nikhil Charles.
Thank you.
Okay.
Good morning. Hey, this is Tim Rather. I have Cordell Nelson for a calendar.
Nelson?
Correct.
Okay, you guys, you have to listen out for the names. We don't want attorneys shouting out. So that's why we're asking you when we call the name of your defendant to indicate that you were here. All right. Like the person you have on here is,
For real.
it's Charles.
Oh, you're gonna do it. No, it's going like that.
He was on here. He just, I think he missed his name when he called.
So you wanna call Charles first?
Yeah, because none of the A's were here, right? Armstrong or,
First.
yeah, I definitely can't think of different names, because I got Alan.
All right, now Charles. This is case number 204312. People of the state of Michigan versus Nikhil Charles here for sentencing. Appearances for the record.
Good morning, Your Honor. Andrea McCray appearing on behalf of the people, P number 83698.
Good morning, Your Honor. May it please the court, Bertram Johnson appearing on behalf of Nikhil Charles.
Good morning, Mr. Sager. John Watkins.
Where is Charles?
Mr. Charles should be on.
Mr. Charles? My goodness gracious. Okay, well, we can't do a sentencing without the defendant.
Yep, I'll try to call him, see what happened.
All right, we'll go to the next person then. Let me get my clerk. You okay?
3 minutes.
Okay. All right. Hold on, you all. We need to take a break for a minute. Okay, just to let you all know, my clerk is a little sick. Hold on 1 second. We need a few minutes, okay? Can you hear me?
Yes, Your Honor, thank you.
Yes, thank you, Judge. Judge, would you have any idea where your docket would be for arraignment on the information in custody case?
Yes, my next emergency docket is on April the 19th at 1 o'clock. It is docket D as in dog.
Thank you very much.
Okay, so if you are on the call and your defendant is in custody, you will not be seen until April the 19th on docket D at 1 o'clock. Yes, that's fine.
Parties on FERRAIUOLO, Ferrelio.
Here, Your Honor.
Good morning, Your Honor. May it please the court, Mike Frez on behalf of.
We have not called the case yet.
Oh, my apologies.
Number 193379, People of the State of Michigan versus Jerry Ferrelio, scheduled motion hearing. Appearances for the record, please.
My apologies for jumping ahead. Mike Frezza for the people.
Good morning, Your Honor. Nicole Evans on behalf of Mrs. Ferriulo.
And
morning.
I'm here.
Mrs., please state your last name for me.
Farah Yulo.
Ferriulo. Okay, good morning to all the counselors. This is date and time set for a motion hearing. There was a motion hearing that was filed by defense regarding motion to correct an invalid sentence, to vacate the stipulation for restitution hearing. Each party and the people did reply. People's consolidated response and brief and support to defendant's motion. I have read both. Is there any need for anybody to say anything else? If not, you can stand on your briefs.
Your Honor, can I just state something very shortly?
Very, very shortly, because
It'll be very, very short. I just wanted to say that I had named this motion, motion to correct an invalid sentence, but I do see that that's a little too broad, because all I'm asking for, I mean, generally is for the court to amend the restitution, which under the amended MCR 6.430, the restitution court rule, a request for amended restitution can be filed at any time, and there's no time limit when it must be filed. And so it can be filed as many times as necessary. So it just is a preliminary matter, and this is all I really need to speak on. This is a timely motion. It's not a motion for reconsideration. It can be filed as many times as you want.
Ms. Evans, you argued all that in your brief already.
Oh, okay. I didn't actually have that particular instance, but that's all I needed to say. I appreciate the opportunity, Your Honor. Thank you.
Your Honor,
Okay.
Your Honor, briefly, to the extent that the defense is modifying or amending and providing different bases, the people have not had an opportunity to respond to that, and it would be unfair to the people to rely on what defense has said to this court, and now some weeks later try to switch up and modify the basis, not unlike the attempt to modify the restitution that was stated on the record in open court.
Okay.
I'm not
going back and forth, Ms. Evans.
Okay.
It's really a pretty much cut and dry. First of all, this same motion that has been brought by the defense was already argued before Judge Boykin. The exact same thing with respect to the stipulation to the restitution. He already ruled on it. He even requested the transcript from the plea as well as from the restitution hearing, which was set. There was a restitution hearing because at the time of the plea, there was a dispute as to what the restitution would be. A restitution hearing was set. And at the day of the restitution hearing, both parties came in and indicated there was a stipulation as to the restitution. This argument about the defendant not being under oath is irrelevant because we don't put defendants under oath for stipulations. The parties stipulated that this was the amount of the restitution. So as to the brief that is before the court, which is a motion to correct an invalid sentence, this is not an invalid sentence, as I guess now the defense has correctly realized, because the sentence is proper. It's not outside of the guidelines. There's nothing illegal about the sentence in that there's not a charge that's running consecutive when it should be concurrent. This is a valid sentence, and it only can be changed within a 6-month period. The month it would have to have been requested under MCR 6.429A or B. So we may not modify a valid sentence. On top of that, I understand that the people are now indicating that it's just an issue of restitution. And I understand that, but that argument was brought before Judge Boykin. He asked for the transcripts. He gave the parties an opportunity to speak on it, and he denied it, indicating that a stipulation was entered into. If the defendant had an issue with her attorney or with something that her attorney was telling her, at the restitution hearing would have been a time to say that. Specifically, on page 4 of the plea, the defendant was asked, "Are you satisfied with the services counsel has rendered to you?" And she said, "Yes." "Has anyone forced you to do this?" She said, "No." It wasn't for months later until the sentencing wasn't even had until July. She pled, I believe, in March or February, actually. There was supposed to be a restitution hearing in March. Everybody came to the restitution hearing, which would definitely have been a time to deal with the restitution. And at that point, both parties stipulated what the restitution was. So as to the defendant's brief to modify because of an invalid sentence, that is being denied because the court rules don't allow the court to modify it after 6 months anyway. Secondly, you're not asking to invalidate the sentence. You're just asking to modify the restitution. I'm not going to vacate a stipulation or hold a restitution hearing. Your proper probably rolled at this point, considering she took a plea and it's by leave, is you can go to the Court of Appeals. And if the Court of Appeals indicates that there is a reason for
the plea itself to be vacated. Because really that's what it is. At this point, you're asking really, that's what's gonna happen, because we're not gonna just change the restitution amount, because the plea is an invalid plea and the sentence is a valid sentence. So that being the case, the motion that defense filed has been denied.
Your Honor, if I may.
No, you may not, Ms. Evans.
It's
Anything else you need to do, you can go to the Court of Appeals by leave.
I will, but I was just going to ask if pending that appeal, if we could just stop the collection efforts, just pending appeal in this matter, so that, I mean, they'll rule on it and then they can collect the restitution.
No, I'm not gonna do that, Ms. Evans. I'm not gonna do that.
Okay, thank you.
Thank you.
Thank you, Your Honor. Have a good day.
Thank you too.
One was the modification of the sentence, right?
Yeah, it was one motion, a motion to correct and invalidate the sentence. It's all denied. Okay, is Mr. Charles on the line now?
Morning, Judge.
Good morning, Ms. Ferrario, your matter is concluded, so you can hang up. All right, no, Mr. Charles? Okay, we're going on to the next person. Was that, Gray? Here we go.
Parties on Gray, get ready.
Ready.
This is case number 21965 and also 21663. Both here for calendar conference, both people of the state of Michigan versus the Terrence Gray. Appearances for the record, please.
Good morning, Your Honor. Andrea McCray appearing on behalf of the people, P number 83698.
Good morning.
Good morning, Your Honor. Edward Taylor, P 57166, appearing on behalf of Mr. Terrence Gray.
Good morning, Mr. Taylor.
Good morning.
Is your client on the call?
He should be, Your Honor. I talked to him earlier.
Okay, I haven't heard anybody say their name. Is
Well,
I see Mr. Gray. Mr. Gray, you have to unmute yourself. State your name for the record.
The Terrence Gray, Your Honor.
Good morning, Mr. Gray. How are you?
Great.
Good. Okay, is there an offer from the people on this?
Yes.
Your Honor, I have something for the record. I have another attorney.
You have another attorney?
Yes, ma'am.
And who is that, Mr. Gray?
1 second, ma'am. Mr. Brandon J. Chris.
Chris, is that C-H-R-I-S?
K-I, hold on, man. Brandon, B-R-A-D-O-N-J-K-I-Z-E-S-Q.
All right, is there a Mr. Chris on this line? Okay, sir, Mr. Gray.
Yes, ma'am.
Mr. Chris is not on this call. Have you officially retained him?
Yes, ma'am. Got to return it right here.
Okay, then what I would suggest you do is mute your phone and contact your attorney and tell him that you have a matter up and that the court has called your matter and he needs to log on to court today, okay?
I got you right now. I got you right now, ma'am.
You need to mute your phone though, Mr. Gray, okay?
Yes, ma'am. Yes, ma'am.
Okay, all right. Mr. Taylor, I would suggest holding off for a second.
Yeah, but because I spoke to the gentleman yesterday, he didn't make mention of that. No problem. Okay.
Okay, yeah, just mute your phone. We'll wait and see what's going on.
All right.
Okay. Hawkins?
Yep.
Parties on Hawkins, get ready. This is case number 203946. People of the state of Michigan versus Jason Hawkins. Scheduled pretrial. Appearances for the record, please.
Good morning, Larry King for the people, P78774.
Good morning. I'm sorry.
Go ahead.
Yes, good morning. Earl Washington, Neighborhood Defender Service of Detroit, 31383, on behalf of Mr. Jason Hawkins.
All right, is Mr. Hawkins on the line?
Yes, I
am, Your
thought I
Honor.
saw him on Zoom. Yes.
State your name for the record, Mr. Hawkins.
Jason John Hawkins.
Okay, and good morning, Mr. Washington.
Yes, good morning, Your Honor.
Okay, what are we doing on this? Is there an offer for the people, from the people?
Your Honor, this case is a no reduced plea case. There is not an offer, and I don't believe there will be an offer.
All right, what is Mr.
Well, Your Honor, I believe Mr. Hawkins wishes this matter to be set for trial.
That's exactly where we were headed. Okay, well, what's gonna happen now then is my clerk, or not my clerk, my JA, Ms. Hope Kennedy, will send you all a trial readiness form that needs to be completed. Once that trial readiness form is completed between the two of you, send that form back to the court, and then the court will send that form to court administration. All jury trials are scheduled through court administration. The court cannot schedule their own jury trials. And they are done with respect to all the judges in the building. I will tell you that because Mr. Hawkins is out, it will probably be a while. Jury trials are not scheduled to start now until June. So I'm gonna put a note on here indicating that we'll send a jury trial readiness form today. And I'm gonna give you a new date to come back with, and everything on that form should be completed. All right, today is April the 14th. Okay, we will be back here on May, I think it's the 12th. May the 12th. There have been emergency document on that. No. Okay, May the 12th at 9 o'clock.
All right. All right. Thank you, Your Honor.
Hey,
Okay, and that, make sure that the trial readiness form is in before that day so that the court can go over it, okay?
Okay.
Okay,
Mr. Washington.
thank you.
Okay. I'll talk to you on the phone, Mr. Hawkins.
Okay, I just wanted to request, maybe I can get this tether off since it's been 8 months and no trouble.
Your Honor, Mr. Hawkins is requesting that his tether be removed. He said it's interfering with his work.
Your Honor, and the people would object to that request, and I can elaborate more if the court would like.
Well, first, let me ask this, Mr. Hawkins, what does Mr. Hawkins do for a living?
Construction, Your Honor.
So you're outside?
Inside and outside. I do drywall, flooring, repairs, painting, pretty much everything.
Okay, who do you work for, Mr. Hawkins?
He's a private contractor, works for a company, DeVerno.
I'm sorry?
It's inside. Right now, it's just inside. We do painting outside, but right now my work is just inside. We're completely renovating a home.
All right, people,
Your Honor, if people would object to modification of the bond and removal of the tether, these are very serious charges, and we have a cooperative victim in this matter. There is a exclusion zone around the victim's place of residence, and it's been alerted to me that he's come incredibly close to violating that exclusion zone on several occasions. I think the tether is actively keeping him away from the complaining witness. Additionally, there was an allegation brought to my attention regarding a possible tether violation by a third-party non-complaining witness. We were able to look into that using the tether unit and discover that there was nothing there. So the tether not only is protecting our victim, but it's also protecting Mr. Hawkins from allegations that he's having contact with the victim. I think the fact that it's been 8 months and there's been no trouble, as Mr. Hawkins said, is indication that the tether is doing its job. And I don't believe he's demonstrated a real hardship by having that tether on. So we would object to the removal of the tether condition at this time.
What are the alleged facts of the case, briefly?
Your Honor, this is a strangulation case involving an intimate partner. It's alleged that he attacked his intimate partner by strangulation.
Okay. All right. At this time, I'm going to leave the tether on.
All right.
Okay.
All right.
Thank you.
All right. Thank you. Have a good day.
I appreciate it, Your Honor. Thank you.
Okay. Let's move on. What do we have next?
Next is parties on Thomas. This is case number 178170. People of the state of Michigan versus Ronald Thomas. Here for a motion hearing. Appearances for the record, please.
Your Honor, Grace Burton appearing on behalf of the people.
You gotta speak up.
We can't hear you.
Good morning, Your Honor. This is Grace Burton appearing on behalf of the people. P80298.
Good morning, your camera on? Hold on one second. Madam Prosecutor, I need your camera on.
Your Honor, 1 second, please. I just realized that my camera is still plugged in. 1 second.
Your Honor, Joseph Dillard on Mr. Armstrong. Is it possible to transfer me to a breakout room with Mr. Armstrong?
Is your client on the call?
Yes, he is. He's called me. He's indicated that he's there. I haven't checked the participant list.
Okay, Mr. Dillard, why don't you and your client are both out. Mute your phone and call your client on the phone. I really don't want to do breakout rooms because it takes too long from the docket. If people are in jail, that's different. But both of you all are out, so just call them on the phone. Just mute your phone.
Okay, thank you, Your Honor.
Okay. All right, Ms. Broughton?
Yes, Your Honor. I'm right here.
Okay. All right, Defense Counsel?
Good morning, Your Honor. Wyatt Harris, P54891 on behalf of Ronald Thomas. I did see Mr. Thomas on, at least his name. I didn't see his face. Mr. Thomas, would you state your name, please?
Mr. Thomas, turn your camera on. Mr. Thomas? Do you have his number? I'm sure you do, Mr. Harris. Can you text him or somehow call him?
Yes, I can, Your Honor.
All right, mute your phone while you're doing that.
Thank you.
Yeah. Okay, hold on a second. The power outage we had earlier has knocked us off of YouTube.